Our first presenter in this forum is Carmela Marshall. And as you can see in her bio, Carmela is speaking as one of the founding members of the Lakeridge Citizens for Clean Water. The LCCW formed in the autumn of 2010 over concerns of a large-scale fill operation on Lakeridge Road. Carmela is an outdoor educator with a degree in microbiology and an engineering-level training course in contaminated soil and groundwater chemistry, assessment, and remediation. Welcome, Carmela.
Good morning. I am very pleased to represent LCCW today. We would like to thank those community groups and NGOs who have shared their knowledge and experiences with LCCW and who continue to encourage actions that demonstrate respect for the environment that sustains us. Before I begin, I want to mention that I have quite a few slides, so I will be skipping quickly over some of them, but the full presentation will be available for review on the KRCA website. Something we have come to understand in our research is that the development boom in Southern Ontario has created what some may consider to be a multi-million-dollar soil movement industry. In some cases, we feel that the profits to be made by accepting excess fill materials can undermine good decision-making processes. An excerpt from a Lake Simcoe Conservation Authority report indicated the following. For landowners, the offer of getting paid up to $60 per triaxle load to accept fill material often clouds their judgment and awareness of the quality of material that they may be receiving. That being said, we do want to point out that we understand that not all fill is contaminated, nor does all fill pose a threat to human or ecological health. However, based on documented evidence we have gathered over the past 2.5 years, we have come to understand that substantial problems do exist. From a community perspective, we have compiled a list of several issues, as you can see here, that we tend to see over and over again. With regards to the lack of public consultation, for some of the more contentious large fill sites we have seen, such as the one located adjacent to the seniors community in Tecumseh, the sudden line of trucks that can number in the hundreds per day often catches neighbors and nearby communities by surprise. There is usually no public warning prior to the commencement of operations. So naturally, when you are living in an area that does not normally see that degree of industrial operation, the result is usually justified confusion by the community and a flurry of phone calls to the local planning authority. For the seniors in the New Tecumseh subdivision, the noise and dust has had considerable impacts on their day-to-day lives. Some residents have been driven from their homes as the noise and banging of tailgates becomes unbearable, while others remain indoors in order to gain some reprieve from the dust. Loss of public trust is also a concern. There can be many contributing factors. Operating sites illegally or seeking permits only after getting caught without them does not instill much faith in the operations of those fill sites going forward. This particular site in Pickering was operating for months without a permit and was shut down after citizens brought it to the attention of city staff. Other times there is a blatant disregard for the law, as was the case here in Scugog, where operations remained active in a rehabilitated gravel pit despite the withdrawal of permission from the local authority. As well, it is often the quantity of fill deposited that leaves some members of the public questioning the necessity of the volume needed. For this property in Clarington, it is alleged that the property owner has indicated uses such as a residential subdivision or an asphalt plant. However, no definitive use is yet understood by the community. Indeed, significant zoning amendments would be required for the uses suggested. Planning staff have indicated no such applications to date. Some members of the community are left extremely frustrated and confused by the situation. Trust issues only worsen when contamination is discovered. We are aware of several sites where the importation of contaminated soils did occur. In Pickering, for example, a report by the city's consultant revealed that fill was coming in from development in downtown Toronto. Fill quality reports were reviewed by city staff and all was determined to be in line. However, independent testing by the city's consultant revealed adverse test results for every random sample taken on the fill site. In the city of Kawartha Lakes, a property owner brought in fill materials in order to further rehabilitate an expired gravel pit to pasture lands. The Ministry of the Environment staff indicated that soils were deposited on these lands from a soil remediation facility. Independent testing by the MOE last June revealed exceedances of contaminant concentrations in all samples taken. So how does this happen? We believe that how the soil is managed at the source and at the receiving site plays a significant role. These are a few comments documented by MOE provincial officers in orders issued for some fill sites in the Durham region. We believe that they indicate significant soil management issues for fill operations, despite, in some cases, qualified persons overseeing activities. As one comment reads, the amount of sampling was not sufficient, and how the sample information relates to the material that was, in fact, deposited at the site is not clear. Poor management aside, it is ultimately the lack of regulation at all levels of government that plays a key role in issues concerning fill. We understand that for many of the large fill projects we have seen, a significant amount of the imported soils is coming from brownfield redevelopment projects in the GTA, either directly or indirectly through soil remediation facilities. A few points pulled from the MOE's website indicate that brownfields can pose a risk to human health because of the potential for contaminants to be left behind, and that redevelopment of brownfields helps protect valuable green spaces and farmland. However, what came as a considerable shock to LCCW in our research of the brownfield regulation, namely Ontario Regulation 15304, and was confirmed to us by MOE staff was the following. Under the regulation, the MOE does not require testing of the excavated material that has gone off of the brownfield property. The ministry does not regulate or require a record of the quality of any soil removed or where any soil excavated goes, nor does OREG 153 require that it be tested. It is usually up to the qualified person of the particular project to address if the material is a waste or if the material can be reused on another site. For LCCW, what is most concerning about the regulation is the critical omission regarding the lack of testing of excavated brownfield soils. For others, it is how one interprets the idea of green space protection that is of importance. With regards to the MOE's their draft guidelines, LCCW, along with other stakeholders, notes a significant omission from the BMP, and that is the absence of specific standards that would indicate acceptable soil quality for excess soils. Ministry tables, such as the one shown here, were developed for use in brownfield regulation. However, these tables are being used by industry and planning authorities outside of their prescribed use. The ministry has provided no other relevant standards. We would like to point out that these tables are clean down to tables and not pollute up to tables, as indicated by the Canadian Council of Ministers of the Environment. Indeed, the spirit of this statement is recognized and valued by industry as well. The Residential and Civil Construction Alliance of Ontario, for example, has incorporated this concept into their 2012 BMP for the handling of excess construction soils in Ontario. An excerpt from this document indicates that soils from source sites are to have concentration levels of substances that are comparable or below that of the receiving site soils. And with regards to municipal regulatory gaps for large fill sites, we worked collaboratively with Earth Roots in a gap analysis study of 56 bylaws in Southern Ontario. And I believe Earth Roots will be discussing this study in their presentation. Recognizing that federal regulatory gaps are a concern as well when it comes to fill and aerodromes, we would like to point out that the Township of King passed a motion recently that addresses the confusion around federal jurisdiction. We've included an excerpt here. Considering the wide distribution of aerodromes across southern Ontario, and taking into account that some airfield owners are now declaring the need for significant quantities of fill to pursue airfield renovations, it is hoped that the various authorities here today support the Township of King's motion or pass their own similar resolution in order to encourage federal review of existing legislation. LCCW has retained the services of legal counsel in order to provide an opinion on municipal powers and enforcement of site alteration bylaws at airfields. This is an excerpt of the opinion we received from Counsel Ian Blue, and Mr. Blue is present here today. Thank you, Ian. Mr. Blue welcomes your questions during the break. So in terms of some possible solutions, aside from requesting that the province address the relevant gaps in their regulations and guidelines, which many authorities have already done, a comprehensive site alteration bylaw or fill policy for CAs is necessary. We've listed some recommendations here for your review. I won't go through all of them, but as it will be available on the website. But to name a few, we encourage prohibiting large fill sites in various sensitive areas, and we qualify this in our appendix to our presentation. Mandating public consultations for larger projects, abiding by CCME guidelines of not polluting up, and performing frequent independent audit tests of incoming fill materials. We also want to mention, we feel that East Gwillimbury has one of the most comprehensive bylaws we have seen to date. The accompanying operational guideline is particularly well done, and that bylaw is still in draft but available on their website. For roadworks and infrastructure projects, the soil bank idea can be an option. And I'm just running low on time, so I'll just skip ahead here. Another possible solution is that for any brownfield redevelopment, we suggest considering putting conditions on development permits at the municipal level, such that required testing of excess soils is mandatory, and proper approvals and consent from local authorities where the fill is to be shipped is received prior to any building permit issued. This could decrease illegal dumping from brownfield development projects. It also has the potential to better address the quality of excavated soils from brownfields. However, the City of Toronto does have some concerns, as indicated in this 2012 staff report. An unfair burden on Toronto development is highlighted. And this slide is just a summary of our recommendations just discussed. And finally, we want to speak briefly about some specific concerns regarding large-scale commercial fill operations in extracted aggregate areas. A review of some studies regarding water quality issues in aggregate sites indicates that it is usually not the extraction process itself, but the post-extraction land use applications that has the potential to impact groundwater quality. We believe we have presented some important evidence to consider regarding fill quality concerns and the use of former aggregate sites for large fill operations. We also feel there is the potential for the business of commercial fill operations to undermine various meaningful and innovative rehabilitation opportunities for some aggregate sites. Opportunities such as those researched in the Ontario Aggregate Resources Corporation Best Practices Guideline for Aggregate Rehabilitation Projects. And we have provided a link to this document in our appendix as well. This particular site, operating under a site alteration permit in East Gwillimbury, involves operators filling beyond the areas permitted by their site plan, resulting in a 3-story high mountain of fill being deposited on adjacent farmland. The town did order them to stop, and there was compliance. However, for some residents, there is still uncertainty as to how the end goal of restoration of this expired gravel pit to farmland can be reconciled with the operations that have taken place on this site to date. As well, it is important to note that the Lakeridge site in Scugog is currently featured, as discussed before, on the Ministry of Natural Resources website, where it is showcased as a successful rehabilitation. However, after commercial fill operations were introduced on this site in 2010, we feel the physical impact to the land, as shown here, has significantly denigrated an otherwise model rehabilitation effort. Furthermore, the importation of contaminated soils, which have yet to be removed from this site, has many citizens concerned that more aggregate sites may end up being used as dumping grounds for vast quantities of questionable fill, thereby posing an unacceptable risk to groundwater quality. And we would like to end with this quote by the Environmental Commissioner of Ontario, spoken at the Moraine Hero Awards ceremony in 2006. We believe that the spirit of this comment will resonate for many present today. The Ministry of Natural Resources and the Ministry of the Environment are so under-resourced that they can't do the job that the public expects them to. They haven't got the troops, they haven't got the expertise, and they haven't got the money. The people must do it. Because if the people do it, it tells the government that it matters to the people. It is absolutely the right thing to do. It is truly a noble thing for people in the community to monitor not only the ecology, but also policy to make sure that the ORMCP is successful. Thank you to the KRCA and the Township of Scugog for inviting us today, and thank you all for your attention.